I am Ohoon Kwon, partner at Cha Kwon Law Offices in Korea. In last video, we talked about the categories of VASPs and how would they be defined under the Korean law. Interestingly, there are some crypto businesses who might be not considered as a VASP in Korea. And one example is actually ICOs, initial coin offering projects in Korea. They might not be regarded as VASPs. So in this video, we'll talk about ICOs, a way for businesses to raise funds by offering new cryptocurrencies. That is a very good question, but also very hard to say. Back in 2017, the government made a press release stating that they are banning all types of ICOs. So after that, people believed that ICOs are restricted in Korea. However, apparently, there are no legal grounds saying that there are no law or rules that prohibits ICOs in Korea. So as long as the crypto business follow the rules, the general rules, ICO itself has not been restricted by any means. However, you should be aware if a token would be deemed as a security under the Capital Market Act, then the rules on securities will apply to the tokens. So you need to care about that part. We'll have to see on how the government will apply the new AML requirement to ICO projects. But in order to determine whether or not AML requirements would apply, we need to see the definition of VASPs again. As discussed in last video, VASP is defined as a business that conducts the buying, selling, exchanging, etc. of virtual assets. However, you need to focus on the term business on this definition because many times if a project performs ICOs, it is just doing it for just one time, which means that it doesn't repeatedly do issue tokens. Many times it issues tokens just one time. And in Korea, the term business means something that you do repeatedly, not just once or twice, but for several times. So if a business claims that it issued a token just for one time, then it might say that the issuing of the token itself is not for business, but their business is for something else. So that's one part that you can go away with the definition of VASPs. One other thing that you need to consider is the definition of virtual asset service provider by the FATF, which is the global institution focused on AML. According to the FATF, the virtual asset service provider is someone who do business for the clients and performs the transferring of the assets for the client. But let's look at the situation for the ICO projects. For ICO projects, they are not selling the tokens for the clients or transferring for the clients. They're selling the tokens for themselves. They're selling the tokens from the entity to another, and that's it. And in that case, we may say there are no transfer of crypto assets in this case. So this is very complicated matter. But if you see deeply and look at the full picture, one might say under the new Korean law, ICO projects might not be considered as a virtual asset service provider. Yes, indeed, it's very complicated and we cannot simply have a simple conclusion regarding the matter of ICOs and AML. However, if you look at the big picture and see it thoroughly, you may have a different conclusion than what is simply said by the others, where you may avoid the requirements by the AML law by looking thoroughly. And we strongly advise to go to a competent lawyer to look at your project and see if your project would be required to follow the recent AML law in Korea. As we have looked at many projects conducting ICOs in Korea, if you have any questions or comments, please do not hesitate to let me know. You can ask in the comment section below, or we have left our contact in the description. So please let us know. If you like this video, please don't forget to like and subscribe so we can prepare more informative videos for you. We will come up with more interesting videos regarding cryptocurrencies, blockchain, finance, and others, so stay tuned. Thank you.